thank you very much for the introduction, and thank you all for being here this evening. It's my honor to be with you. Let me see if I can get started. As you mentioned in the introduction, I do my work on the intersection of American law and Islamic law, and in my recent book, this talk is not about my recent book, but my recent book on the unfamiliar abode, Islamic law in the United States and Britain, is a book that I'm going to present to the Pacifica Institute. As I want to give you this book for your library. And in this research, I've demonstrated a movement toward increased recognition of Islamic legal norms within the American legal system. And this is a movement that I believe is born of a commitment to and respect for pluralism. So the current book project that I'm working on now, which is in the beginning stages, takes this analysis of pluralism and a little bit further to make a comparison between four important religious groupings in the United States, Muslims certainly, but also Mormons, Catholics, and American evangelical Protestants. And so what I want to talk about today is an introduction to that. I tentatively call this When the Religious Turn Litigious, Constitutional Interpretation for the 21st Century. Religious discourse has an important function in the making, practice, and adjudication of American law, not the least because the laws rest upon a foundation of religious values. I don't know if this is working, if you can hear me or not, but oh, that's for the camera. I'm sorry. I thought it was amplified for this. All right. So I hope it didn't ruin anything there. But I think that the reason that religious discourse today in contemporary politics plays such an important function in the making and practice and adjudication of American law and politics is not the least because these laws rest on a foundation of religious values. And the relationship between religion and law is clearly a hot-button topic in today's atmosphere in religion and law and politics with the courts and journalists and politicians and many other kinds of commentators engaged in an animated conversation about what influence religion ought to have on the law, if any. And there's a deep divide in American life over the role that belief should play in the business of politics and government. Roughly, Pew Forum on Religion and Public Life tells us that roughly 54% of Americans believe that religion and government is bad. 54% is, that means that roughly 46% feel otherwise. So this is a pretty contentious issue. And in many instances, the perspective is that religion poses a threat to law. And it is rare to hear how various religions view American law, although most major religions have taken definite positions about secular authority and ethics. There are secular ideas about America, and then there are religious perspectives on America. And the idea of America as a religious concept has received considerable scholarly attention with respect to American Protestantism, and yet it remains to be explored when it comes to America's other religions. And to study how other religions, other than Protestantism, have defined America's sense of national purpose in general is what my work is about. I look at the constitutional arguments that are made by Catholics, Mormons, and Muslims alongside the Protestant evangelical groups that have litigated on key constitutional issues. So the myth of America exists in many different forms, and closely associated with the myth is a sense of national purpose or mission. Historically, the dominant myth has been the Protestant master myth of America, and there are two strong biblical motifs that form the historical taproot of America's sense of destiny. The Puritan America's identification with ancient Israel and with the kingdom of God. So what I argue is that the first generation of Puritans that arrived in the New World literally saw the New World as their opportunity to create the millennial kingdom. the truly righteous nation that had been founded and had gone off track due to the influence of the Roman Catholic Church and then the church establishment in the Church of England. The Puritans believed that God's promises to ancient Israel were also promises that applied to them as well. And this is the chosen land for the New Jerusalem. This is the chosen land for the New Zion. And the New Jerusalem in this land would be that promised shining city upon a hill. The New Jerusalem would be a place where the old world would cease to exist, and the new heaven and the new earth would be created. So these were very powerful biblical images in the day of the Puritans. And beginning with the Puritans, the Protestant mission in America was to colonize and to Christianize and to civilize. The Puritans may be long gone, of course, but the vestiges of the religious meanings that they invested in America persist to this day. You don't have to look too far, simply to the rhetoric of President Reagan, where President Reagan, when he was governor of California, in his address to the first Conservative Political Action Conference in 1974, said this. He said, standing on the tiny deck of the Arabella in 1630 off the Massachusetts coast, John Winthrop said, "We will be as a city upon a hill. The eyes of all people are upon us, so that if we deal falsely with our God in this world, in this work we have undertaken, and so cause God to withdraw his present help from us, we shall be made a story and a byword throughout the world." Reagan goes on to say, well, we have not dealt falsely with our God, even if he is temporarily suspended from the classroom. This from his address called "We Will Be a City Upon a Hill." Now, Reagan's use of this metaphor of a city upon a hill worked very well for him. He used it not only in 1974, but he used it again in 1984 in his acceptance speech at the GOP nominating convention. And then he also repeated it again in 1989 in his farewell address at the end of his presidency. And it comes from the Puritan minister Winthrop's address to the Puritans on the ship of Arabella in 1630, where Winthrop was citing the Gospel of Matthew, chapter 5, verse 14, where he says, where he writes, "You are a light of the world. A city set upon a hill cannot be hidden." So in the public mind, the city upon a hill metaphor has always been closely associated with President Reagan since the 1970s. But actually, what's less well known is that it was also used by President John Kennedy, a Democrat, in 1961. Kennedy, in his inaugural address, referred to the city upon a hill and John Winthrop, where Kennedy says that in his address when he was elected as, by the way, the first Catholic president to the United States, that we must always consider that we shall be as a city upon a hill. The eyes of all people are on us. Today the eyes of all people are truly upon us, and our governments in each branch, at every level, national, state, and local, must be as a city upon a hill, constructed and inhabited by men and women aware of their great trust and their great responsibilities. He went on further to say, "For we are setting out upon a voyage in 1961 no less hazardous than that undertaken by the Arabella in 1630. We are committing ourselves to tasks of statecraft no less awesome than that of governing the Massachusetts Bay Colony, beset as it was then by terror without and disorder within." So conservatives, and particularly in the Republican Party during the 20th century, have tried to portray themselves as the defender of religion against a hostile and rampant secularism. And it's not often remembered that it was also a Democrat who used this city upon a hill metaphor very effectively. The ideals that this enshrines are part of the symbolic construction of America, a construction recently which has been framed as the debate between the pro-religion conservative right and the anti-religion or secularist left in American politics. And this is a division which affects beliefs also about the Constitution and proper constitutional interpretation. I'll get to that in a few minutes, but first, to speak further about politics. The religious visions of the nation of America, common to most of these religious visions is some sort of belief about linking God and country. Any belief that links God with America, I think, can rightly be thought of as a theology of America, as sociologist Dean Hodge has pointed out in an article in 1976, when he said, any living religious community has theological views about many things, and these things include the nation. In America, such views might be called a theology of America. Well, what might this theology consist of? Just as there are different religions in America, so there is also a range of religious visions of the nation. So in a word, America was founded on religious ideals and continues to be reshaped by these ideals. Many have said that America is a deeply religious nation. Over 90% of Americans believe in the existence of God, and 2/3 belong to a church, synagogue, mosque, or other house of worship. 3 out of 4 Americans pray at least once a week, and 60% say that religion is important in their lives, while only 14% of Americans say that religion is not very important at all. And these figures are reported by the Pew Forum on Religion and Public Life. Now, against this background, then, it's not very surprising that religious visions of the nation and the role of religion in politics persist, even in spite of there being a separation of church and state enshrined in the religion clause, the Establishment Clause of the First Amendment to the Constitution. After all, these two things, a role of religion in politics and the separation of church and state, are really not mutually incompatible. They're not necessarily inconsistent principles. It's also, though, not surprising that conservative social and political movements since the middle part of the 1970s have come to dominate American politics. Conservative presidents, ever since Ronald Reagan, have appointed the overwhelming majority of federal judges who currently sit on the bench throughout America, stocking the judiciary with judges who are more inclined to accept conservative positions on key issues of constitutional law. And some of these conservatives that are social conservatives will also be religious conservatives, in most cases Protestant evangelicals, who have a particular perspective on their roles in government. And through these appointments, these judicial appointments, and in electoral politics, both, conservatives have sought to reinterpret the achievements of 20th century constitutionalism, things like the expansion of rights for the criminally accused, and the removal of prayer and the Ten Commandments from the classroom, and the abortion issue. And in many cases, conservatives have attempted to roll back the liberal gains that have been made in judicial politics on these issues, beginning from the World War II period until roughly the late 1970s. So that posits there to be a divide in judicial politics, in particular between religious conservatives and liberals. And that divide maps onto a divide between legal secularism and the accommodation of religion in the public sphere. Because for decades now, liberals have tried to defend their constitutional understandings against the conservative mobilization that began in the late 1970s. Liberals embracing a position that's called legal secularism they've taken a particular position on key constitutional questions. And what it means is legal secularism refers to a strict separation between church and state, referring to that metaphor of the wall of separation, where there must be a strict wall separating the church from the wilderness of the world. So liberals have feared that the accommodationism of the religious conservatives would result in there being an America where that wall was no longer impregnable. They fear an America where that would feel like a Christian country because of accommodation of religion, and national unity they fear could never be achieved in the kind of an America, in this kind of an America, you know, where there is no strict wall of separation, as long as some Christians, some Americans were not Christian, and so legal secularism is a position that is taken. It's not anti-religious, but rather being anti-accommodation, meaning that the secularists would prefer to see neutrality toward religion, official neutrality, and they've devoted you know, their attention to keeping religion out of the public sphere. All policy must have a secular purpose and never appear to endorse a particular religious viewpoint. Looking to the courts to embody this ideal of secular government, this legal secularist movement has had great success, as I said, between the years of the 1940s until the 1970s, when the tide began to turn. When the tide turned, then we see a blaze of frustration appearing under the banner of the moral majority and the Christian coalition, which is what I call the values evangelism, which was a movement toward disseminating the moral values of evangelism that are grounded in religion. I just wanted to show that here's a scheme of legal secularism versus the religious accommodation, and I'll get back to explaining these different parties in a few minutes. But what this is the legal secularists in the blue box are the advocacy organizations that have been around throughout much of the 20th century, the Americans United for the Separation of Church and State, the American Civil Liberties Union, and the Baptist Joint Committee for Religious Liberty, that have all taken the legal secularist strict separation of church and state line. And then the public interest law firms that are listed in the green box are the new right, for the most part, the new right public interest law firms, the new right organizations that have taken up litigation to challenge the secularist point of view in the constitutional decisions reached by the Supreme Court during that period from 1940 roughly to the late 1970s. On a related note, I think the public discussion about religion in law in the United States is highly polarized, and as Stanley Fish has put it, it's been hijacked by the political right to portray Christians as a beleaguered minority whose civil rights are being violated primarily at the hands of secular humanists. That's the dichotomy that has appeared in the polarities or the binaries of this particular war, which says that there is a cultural war at foot, that there's a culture wars that describes the struggle over the control of language. Yet, though in the American political text there appears to be a deliberate campaign by conservatives, is what Stanley Fish is arguing, but in my book I argue that there's something much more complex at work. So I explore something else that I think is much deeper than just rhetoric and language, and much deeper than a new culture wars where combatants are basing their legitimacy on their command of political language. Instead, I look at some sustained projects which are often taken, projects that often take place away from the glare of politics to elaborate the positions that are taken that entail some particularistic interpretations of the U.S. Constitution and explore the work of these public interest law firms and other kinds of religious advocacy organizations as they interact and sometimes build coalitions in ways that promote their own understanding on social issues and matters of religious freedom, and that in turn affects their perspectives on the meaning of the Constitution. But before elaborating on that, let's go back for a moment to the framers of the U.S. Constitution and their intentions. Because a number of the political ideas that were anticipated by modern constitutional norms are present from the period of the 17th and 18th century forward, and these constitutional norms guide the practice of interpretation. And one of the ideas that came through during this period of early modernity up to the stage of writing the U.S. Constitution is reliance on the will of the people, the idea of popular sovereignty. And here in the 17th and 18th century was expressed as a distinctly religious form in saying that God had ordained secular government in order to serve the needs of the people. And if it fails to serve this function, then power should revert back to the people who have the right to choose new leaders. Because for roughly 1,400 years, from the time of the Roman Empire until the American Revolution, the question of church and state in the Christian world always began with the simple assumption that the official religion of the state was the religion of the ruler. But all of that changed with the radical idea that the people were sovereign, and that was introduced during the Revolutionary period and embodied in the U.S. Constitution. And also what comes through in the preamble to the Constitution is the idea that the rights of men and women come not from the generosity of the state, but from the hand of God. And so we get, where did that go? We get JFK, to return to Kennedy again in his inaugural address in 1961, saying very famously, "And so, my fellow Americans, ask not what your country can do for you, ask what you can do for your country. Let us go forth to lead the land that we love, asking God's blessing and God's help, but knowing that here on earth God's work must truly be our own." Kennedy's was an appeal to a particularly Protestant spirit of activism. In other words, a call to civic engagement that allowed for national unity because it used the religious dimension of American experience as its foundation for transcendence above and beyond sectarian difference. And what Kennedy was talking about is a civil religion, one that uses the Protestant master myth of America that borrowed from Protestantism all of these national symbols and rituals and metaphors, such as the city upon a hill. And we have moved from this civil religion that borrows these national myths from Protestant symbols toward what is now apparent in American political life as public religion, which is identified by sociologists as that competition between groups in a diverse society to advance a particular sectarian belief as the dominant, if not the only, belief or vision representing America as a nation. So how did we get to this particular circumstance where we went from using religion to provide a reason for transcendence above sectarian difference to use of religion as a basis for division in politics? Well, let's not look at the president, but look instead at Congress and the role of interest group politics, because frequently we see in the political sphere in the last 15 years the dividing up of the American pie into increasingly thinner and thinner slices. The values evangelicals have been the most visible within this approach to public religion. Not being content with electoral politics, they have pushed for judicial appointments and developed their own innovative legal strategy that depicts religious people as a whole, and not just Christians in particular, but all people of faith as a persecuted minority in need of the court's protection. The moral majority and the Christian coalition, of course, were at the outset of this position that's being taken about litigation, but really it's their offspring. The public interest law groups that I mentioned here, as that are the offspring of the Christian coalition. For instance, the American Center for Law and Justice, a Protestant group which is associated with Pat Robertson. The Thomas More Law Center is a Catholic group, and there are others that represent litigation on behalf of people of faith. And there are other organized religious interests that include membership groups like the Christian Coalition and also representatives of religious service organizations such as Catholic Charities. And there are also coalitions of denominations such as the National Association of Evangelicals or the National Council of Churches, which have offices of government relations, and there are over 120 nonprofit organizations that seek to influence policy in the political process from a religious perspective. And they act much like other interest groups. They decide how to apply political pressure and to use their resources in campaigns, lobbying, and direct action. Now, some of this discourse, though, was initiated in response to changing demographics in the United States and the increasing pluralism of America as a nation. Since the late 1960s, as we all know, immigration patterns have changed considerably, and that's resulted in the changing of America. Now, more residents of Asian, Latin American, and African backgrounds are present in the United States, and this has altered the political rhetoric. Where once commentators spoke about the melting pot of Protestant, Catholic, and Jew, now we have a smorgasbord of many different religious and faith traditions. And the Pew Forum on Religion and Public Life shows us that over time, gradually, fewer and fewer Americans identify themselves as Christian, and there's an increasing proportion of the population that identify themselves as none, meaning having no religious affiliation, or as spiritual but not religious, or as a member of a non-Christian other religion. So in the 10 years between 1990 and 2000 alone, Pew Forum has found by looking at US Census statistics that there's a growth in the American population that identify themselves as Buddhist, Hindu, and Muslim that has increased Buddhism by 170% in that decade, Hindus by 237%, and Muslim by 110%. So the question then is, at this moment, at the beginning of the 21st century, can we rethink our commitments and ask what the Constitution means for us today? A consensus is developed behind the idea that pluralism is the best path to deal with this growing diversity. And constitutional interpretation for the 21st century will be fashioned in part by these political and demographic trends. Across America, the parliaments of religion are no longer, the experiments held at World's Fairs or at cultural festivals, but instead are everyday assemblies in schools, hospitals, the workplace, and city streets. Pluralism has come to represent a powerful ideal meant to solve the question of how to get along in a conflict-ridden world. So if we go back to the founding period and the framers of the US Constitution in the 18th century, when the framers were faced with the problem of how religious diversity can be reconciled with national unity in a democratic system, they adopted a solution that might still give us direction for solving that same question for ourselves. The church-state problem was addressed by the framers through a combination of principle and politics. The principled reason behind the religion clauses of the First Amendment was to protect liberty of conscience for religious dissenters. And the political reason was that no one in the new United States opposed the idea of religious liberty, and given the religious diversity of the times, there would be no single denomination, whether congregational or Episcopal or Presbyterian or whatever, that would seriously believe that it could establish itself as the national official religion of its own. And so with each successive period of American history, with repeated infusions of religious diversity into American life, they brought, the newcomers brought new constitutional answers to the challenge of preserving unity in the face of expanding diversity. So if the Constitution of the 21st century is to reflect a coherent perspective on the role of religion in law, one solution would be to offer this. greater latitude in religious speech and symbols in public debate, but also the imposition of a stricter ban on state funding for religious institutions and activities. The move toward faith-based initiatives would need to be reversed, but the prohibition on values-based debate would be lifted. So such a solution would recognize religious values while at the same time would respect the institutional separation of religion and government as an American value in its own right. And this would mean abandoning the argument that religion has no place in the public sphere, while at the same time insisting that government must go to great lengths to disassociate itself from support of religious institutions. And it would mean acknowledging a substantial difference between allowing religious symbols and speech in public spaces and spending resources to sustain religious institutions. So Mormons, Catholics, and Muslims have views of the nation and the Constitution then that would be included alongside American Protestant views. I think I will stop there to take questions. I have plenty of examples, but that can come out in the question and answer period if you like. Thank you very much. Would there be any questions or comments?
I'm sorry, I'm British, and we tend to talk about multiculturalism
Right.
and pluralism, and I've always been slightly intrigued about it. If you just have any take on the difference between those two.
Right, very good question, and since I've written a book that had to do with Islamic law in Britain and the United States, that's a topic on which I've spilled a lot of ink myself. So the idea of multiculturalism, I think, is to incorporate the communities taking them where they are. And American pluralism, rather than taking communities where they are a bit more like the French in that regard in terms of requiring a certain amount of assimilation to, an American model of civic commitment. And so the pluralist model is one that, the melting pot was an apt metaphor for many years and was used favorably because that talked about assimilation, that talked about changing the newcomers to look more like something new. Of course, the melting pot metaphor was popular in the beginning of the 20th century all the way through to the 1960s with the civil rights movement at that point, where instead there became a celebration of ethnic identities. And so assimilation was cast aside in terms of, in favor of something else called integration, where integration allows newcomers to retain some of their cultural distinctiveness, but is still moving toward a model of American civic identity. I think there's a greater emphasis here on the acquisition of language skills than there is in Britain as much. Also, I think with the multiculturalism and anti-racism policy in Britain, that there was more public funding for cultural communities to at least to hold cultural festivals. And it may have been more on the cultural level than it was on the political. That was, public funding was less controversial, it seems to me, than it would be in the United States. Faith-based initiatives have come about beginning in, I think it was 2000, with the George W. Bush administration opening a White House office of faith-based and community initiatives. And that was in part response to what his Attorney General, John Ashcroft, had said was discrimination against nonprofit organizations that had a religious mission that could not get funding as service providers from the federal government, so they couldn't compete for contracts or for grants to provide welfare services or to provide foster care services or adoption services, so forth. They were not allowed to compete on an equal basis with secular nonprofit organizations to do those same services. And so Ashcroft's stated opinion was that that was anti-religious discrimination. And so along those lines of thinking, the White House has become, beginning with the George W. Bush administration, more open to the idea that all nonprofit organizations could compete equally for funding, whether or not they were faith-based. And so that created new possibilities for the civic engagement of these groups that were founded as, or like Catholic Charities or other groups like this, Prison Ministry, which is a Protestant group with Chuck Colson, that there were new opportunities for them to get public funding and would increase their civic engagement, so that pluralism took on a particular cast at that point. That might appear to be more multicultural in that way. And that has continued with the Obama administration also maintaining a White House Office of Faith-Based Initiatives and some public funding. But it's also a very controversial thing. It's still not accepted in the American political scene. Sorry, yeah, and then there were a couple other hands, but I'm sorry.
In England, as you know, Muslims can use, if they prefer to their own constitution, Islamic Sharia laws, in their civic relations, like marriage or some of it, but not the criminal cases, obviously. Do you envision anything like this in this country?
Okay, the question is about accepting Islamic Sharia councils and the rulings of these councils in Britain as formal laws, is officially sanctioned by the state. And you're right that recently the British government has taken that position on issues of marriage, family law, and civil law issues, not criminal law. In the United States, actually, my position is that happens already. Because family law and some of these other civil law issues are subject to the local jurisdiction, they're subject to state law rather than federal. And so there are many instances in cases of marriage and divorce and child custody where the court has accepted that there is an Islamic marriage contract. And they use the principles of contract law to say that all of the provisions of the marriage contract are enforced. They're enforceable as law in the United States. And so regardless of the fact that they come from a religious court overseas, or they may be based in Islamic legal tenets, most judges do accept them, provided that they don't put the woman at a disadvantage. They will not uphold a divorce that they do not uphold a divorce that gives a woman less property than she would get under the property laws, like in California with community property in the marriage. So in most instances, that's the caveat, that the judge won't award something that would substantially disadvantage the woman in a divorce or child custody proceeding. But nevertheless, these state courts have already enforced the principles of Islamic law by upholding marriage contracts and the dissolution of marriage and these sorts of things. And then also many jurisdictions have accommodated halal in places like school cafeterias or hospitals or the military. So there is already, on a case-by-case basis, an accommodation of these sort of dietary restrictions. So that, in effect, I would say is, an acknowledgement of Islamic legal norms within the American legal system. I'm sorry, you had a hand, and then you before we go. Yeah.
Just wondering if you have an update on these statistics, the numbers you have on the screen here for the last decade.
Yeah, I'm sorry, I don't have the most recent. Do you know anything about what might have happened with the population trends?
How much different it might be?
I don't know. I do know because I did an article recently on Pakistani Americans and looked at the census data for the last decade, 2000 to 2010, which shows that even in spite of the setback after 9/11 to immigration, and there was a dip in Pakistani immigration and non-immigrant visas being administered for 2 years after 9/11. But by about 2005, they reached a low point and it began to climb up, just as it did with all other immigrant groups. But so Pakistani Americans were not adversely affected any more than any other immigrant group. And we find also that though Pakistan is the single largest contributing country to Muslim immigration to the United States, so immigration continues to be a source of increase of the Muslim population in the United States, even in this past decade of 2000 to 2010. So we might think that the proportions would have been knocked off by post 9/11 national security concerns and change in immigration, but in fact, I would think if the Pakistani case is any example of all Muslim source countries, I don't think that it would have changed that much. And then Daniel, you had your hand up?
Yeah, thank you. I very much appreciate your presentation of the changing notions of pluralism over time. I'm wondering how your conception of pluralism might handle two contemporary contentious issues. One is the Obama administration's refusal to provide exemptions to Catholic hospitals with regards to counseling and advice on contraception and abortion. Secondly, the Protestant evangelical and some Muslim voices that creationism ought to be in the public school classroom alongside evolutionary studies.
Okay, pluralism with response to those things. With the debate between science and religion, I mean, that is a debate that also, takes up a lot of political rhetoric. And in fact, Bella has come out with a new book on evolution, in which he says in the beginning, my book has nothing to do with the debate between creationists and evolutionary biologists. And so I think I agree with Bella in the sense that it's an internally divisive debate that's going on, but it is something that with time, this will appear to be a blip on the radar screen, and that understandings about some of the more fundamental, processes of religion and politics will go on, will endure. So I think the representation of the creationism debate and whether or not creation science will be taught alongside evolutionary biology is something that is, purely a political debate, and I'm not sure that pluralism really affects that as much as pluralism would affect the first thing that you mentioned about the Obama administration's position in not funding Catholic hospitals unless they will provide counseling that includes abortion as an option in family. Is this what you're talking about there? Yeah. In that case, the response has been to pressures in Congress not to outlaw abortion services, not to cut off funding for medical services that would include abortion counseling among the services that they provide. And so it really is, I think probably a position that Obama himself would endorse, although he has been very tight-lipped about what his own personal position is on the question of abortion. But it is a Democratic position not to challenge what the Supreme Court had ruled in Roe v. Wade. And so I think his decision about the funding for Catholic hospitals is in line with what they believe to be the precedent decided by the U.S. Supreme Court. And so the Congress and the presidency don't want to go down that path to challenge that ruling because it, is increasingly attacked in the political electoral political sphere, even though when you do public opinion polls, the majority of Americans are still in favor of Roe v. Wade. So I don't think he wanted to expend any of his political capital in going in that direction. And so there's where pluralism, I think, might affect that, because I see many of these religious advocacy organizations appealing to a constituency that would reflect some of the newcomers in the United States, that in other words, there's more of an effort to reach out to Catholics from Latin America, Protestants from Asia, and what was I thinking? Many Protestants from Asia and Catholics from Latin America are some of the groups that these public interest law firms and other religious advocacy organizations are seeking to appeal to in their opposition to secular humanism and their promotion of the religious interests of these litigants. Some of the organizations, too, that I want to point out is, for instance, the Rutherford Institute is an American Protestant public interest law firm that is founded by and run by a man named John Whitehead, who has a particular a very specific theological Protestant angle. That institute represents one example of this coalition building with other religious groups in this pluralistic context, because the Rutherford Institute represented a young woman named Nishala Hearn, Nishala Hearn was a young African American in middle school, I think, in Oklahoma. In the early 2000s, she was expelled from school for wearing the Islamic headscarf. And she was suspended a couple of times and continued, when she returned to school, to continue to wear it. And the third time, I think, she was expelled because the school board said this violated their ban on wearing bandanas on the head. The reason for the ban was to prevent children from wearing gang insignia kinds of clothing that would indicate their membership in a gang. So the Rutherford Institute came in to represent her in her challenge, her legal challenge to the school board for violation of her religious liberty. And during the George W. Bush administration, they also flew a government attorney out from Washington to stand alongside her and the Rutherford Institute against the school board and the Department of Education in Oklahoma, and ultimately on appeal won their case. But it's an instance where here an American Protestant organization represented a Muslim litigant to defend her right to wear the headscarf, whereas the same organization sued the Army the year before this because of a captain, a U.S. Army captain who was stationed in Saudi Arabia, and said that she did not want to wear the abaya when she left the base and moved around Saudi Arabia, and felt that the Army's dress code, which required her to wear the abaya, was a violation of her rights as a Christian. So the Rutherford Institute, on that one hand, litigated against the imposition of Islamic clothing, and then in the case of Nishala Hearn, had represented her right to wear the religious clothing. And so there's one case. Another case that I've worked on as, I'm an expert witness on this case, which is still being litigated in Minneapolis, is a case called the American Civil Liberties Union versus Teasy Academy, which is the Tariq Ibn Ziyad Academy. It's a public charter school in the Minneapolis area that has 2 campuses. And Teasy is an academy that is run by members of the Muslim American Society. And their student body are like 99% Somali Muslim. And they've been sued by the ACLU for an impermissible promotion of religion, in part because of the texts that they use to teach Arabic. The purpose of this public charter school is to provide an intensive Arabic language instruction for these Somali Muslims. And the ACLU says it's improper to teach Arabic in the way that they do because there are too many religious overtones to the textbook and other things. So anyway, when I was deposed, I'm an expert witness and wrote a report, and then I was deposed by the ACLU. I was also deposed at the same time by the lawyer of the co-defendant in this case. The defendant, remember, is the Teasy Academy, But this public charter school has to have a sponsor, and their sponsor is the Islamic Relief of USA. So this is a nonprofit organization that primarily provides disaster relief. And they're the sponsor of the school. So they were also sued by the ACLU. Now their co-defendant's lawyer deposed me, and he ended up settling with the ACLU, and so did the Minnesota Department of Education. They've settled out of court with the ACLU. And what's left now is a lawsuit between the ACLU and just the directors of the school. But what was interesting about this is that the lawyer who was hired by Islamic Relief to represent them is a business corporate attorney in Virginia who is also a member of the Christian Legal Society, and he has been part of the Christian Legal Society since law school. And his take on this was that he would represent the Islamic Relief because this was a minority religion and these were people of faith who were being sued by the ACLU, the secularists on the other side. And so after meeting him and being deposed, then I've interviewed him since then as a part of my book. But his motive in doing this kind of work is to represent people who are persons of faith who might be part of this new pluralism that we're talking about because they are newcomers. But that even though they're not Christians, it's important for the Christian Legal Society to represent their legal interests, because the more we expand the rights of people of faith, the more all people of faith are going to benefit. So that was part of their reasoning behind representing Islamic Relief. Even though theologically they don't agree with Islamic Relief, that was part of their issue with respect to religious perspectives in the public sphere. So. Mm-hmm.
I'm curious if you could describe a little bit more what you envision when you say greater latitude in religious political speech, especially considering pluralism and America's lack of understanding of their own religions, let alone
Right. Yeah, when I talked about specifically allowing for greater latitude for religious speech in the public sphere, it would be things like, why are we fighting over issues about the Ten Commandments? Or why are we fighting about issues of religious symbolism in the public sphere when, it's like putting a finger in the dike. Having a display of the Ten Commandments in a classroom or a courtroom is only one instance of where we see religious symbolism throughout the nation. If we were to begin to actually censor that religious symbolism, that kind of religious speech, we'd spend an awful lot of resources and time. I think it would be virtually impossible to eliminate all of it. Even the U.S. Supreme Court itself, on its frieze, on the behind the bench of the Supreme Court justices, have a mural of images of the lawgivers of history, including Moses, including Muhammad, and so even to that level, we have imagery in our country that reflects a religious theme. So for me, this is where I'm talking about greater latitude of religious speech, is basically there's at one level, I think, a fruitless pursuit of expunging all of these kinds of images from the public sphere. And on the other hand, it's also sort of more of a Rawlsian argument about public consensus and public reason, that if you were coming from a religious perspective, you may need to translate the terms, the values that you're using into a language that the greater consensus of greater range of Americans would understand and be able. They may not agree with your reasoning, but at least it's comprehensible to them. And so, in order to reach a consensus among people of many differing values and languages, there may be this sort of filtering process as you enter into the civic realm to be able to take your speech and make it intelligible to people who don't share your traditions. But nevertheless, you emerge with, I think, a stronger sense of national unity in the process. And so those people who are speaking from a religious perspective ought not to be kept out of that whole political debate. That's kind of where I'm coming from with the greater latitude for religious speech in the public sphere. And we see it already. I mean, look at the way that the electoral campaigns are being run. You know, when I was thinking back to the issue about presidents running for office. John Kennedy, obviously, you know, ran as a Democrat, but when he ran in 1960, he was opposed by Nixon, and a lot of Nixon's supporters, some of them made an issue of Kennedy's Catholicism. Billy Graham and other Protestants organized, you know, a campaign to vilify him as you know, we must question his loyalty as a Catholic. Wouldn't he be loyal to the Pope? And he addressed that in a convention of religious ministers, of Protestant ministers. He gave a very famous speech in which he said, you ask me what I believe, and here I'm going to tell you I believe in the Constitution, and I believe in a lot of these sort of civic values. And at the end he said, many people think of me as the Catholic candidate for president, and I'm here to tell you I am not the Catholic candidate for president. I'm the Democratic nominee for the presidency who happens to be Catholic. So when you go into the voting box, the voting booth on election day, I ask you to set aside any consideration of my personal beliefs and vote for the candidate most qualified to be president. And he was very persuasive. In fact, I think his wife, Jackie Kennedy, thought he was very funny because she said, my husband may be Catholic, but he's a bad one. So for her, it really seemed to be irrelevant to the whole race. And I think the legacy of that whole thing was that Kennedy was the one who convinced Americans that it's important to set aside consideration of a person's religious beliefs when voting. And then we, you know, had LBJ and we had Nixon and the whole Watergate issue, you know, where Americans were quite comfortable with the idea that somebody could be qualified to be a good politician but not necessarily be a very moral person. And then by 1976, you know, Jimmy Carter comes about. Americans, again, you know, so the tide had turned because Carter was billed as the Christian, the born-again evangelical candidate for president. And once he was elected, those American evangelical organizations that had supported him quickly abandoned him because it was clear he was not going to support overturning Roe v. Wade, and they ran to Ronald Reagan. So then Reagan became the first, you know, not Carter, but then Reagan was, again, the first evangelical president supported by the Christian right. And then in 2000, in the running for election for president, George W. Bush was asked that famous question, you know, what do you, who's your favorite philosopher? And he was then governor of Texas. And his response was Jesus. And the interviewer said, did a double take and said, well, what do you mean Jesus? And he said, explain, what is it that Jesus said that you admire? And Bush just kind of shook his head and he said, well, you know, if you were a believer, you'd know what I meant. You know, you have to believe in your heart. And I can't put it any more eloquently than that, is what he said. And then as Texas governor, of course, during the campaign, he then returned to Texas after that political debate and declared Jesus Day in the state of Texas. So they now practice this Jesus Day as an official state occasion. So I guess my point is just to say that there has already been this fissure. You know, there's already been this crack in the wall of separation, and you know, the tip of the spear has gone in. And so rather than ignore it or think that we can stem the tide of religious speech, I think that the rules should be set to allow for greater latitude for that kind of religious speech in order to be sure that you know, the least destructive elements of it are being controlled. I mean, I think public representations of official religious doctrine and identity can be constructed in a way where, you know, it's productive, it's positive about contemporary constitutional interpretation. You know, and if we acknowledge that, then we create the opportunity to sort of regulate it and keep, you know, the more divisive elements out of it. Thank you.